General Business, Order of the Day 1, Equal Opportunity Amendment, Medical Treatment Bill 2026, second reading, resumption of debate.
Mr Gleer.
Thank you, Acting President. I'm pleased to rise today to make some remarks on the Equal Opportunity Amendment Medical Treatment Bill 2026. And in doing so, note that I am very pleased to be talking about a bill today that I will come into some detail on, but I do wish to acknowledge that this has been put forward to us by our colleagues in Legalise Cannabis Party, in particular my region colleague Rachel Payne, and also Mr Eddershank as well. I think it is important that, as perhaps peripherally to the fact in a previous debate we've talked about the various roles of our respective chambers here in the Parliament, and this Parliament that we're privileged to sit in, because of course we are the better chamber, has the fortune of being able to take the time to delve methodically and analytically through legislation that appears before us, and I certainly welcome the opportunity to. This is indeed, in different aspects, a topic I've been privileged to speak on over the course of the past 3.5 years, whether it is indeed in engaging with the inquiry from which the recommendations that led to this bill before us today have arisen, or indeed whether it has been in relation to the matter of cannabis use and medicinal cannabis use, in fact, whilst driving. So the inquiry did set forth and received a number of submissions from different stakeholders and had witnesses appear, which I was regrettably not able to attend the hearings of, owing to the fact that I was in another committee at the time in the Pay Act, but did certainly engage with the process of this inquiry and certainly found reading back the transcripts of hearings and indeed the submissions quite fascinating. I'll come back to the report a little bit later in my contribution, but what this bill fundamentally seeks to do is to implement a new section of the Equal Opportunity Act by specifically having a provision of protection for people's medical treatment for whatever condition they may be suffering from, and be having a diagnosed or prescribed treatment for. That may include medicinal cannabis, or it may be something else altogether, and my remarks will vary across the two facets of that in my contribution today. What this really is about is the meeting point of workers' rights and workplace safety, and it's something that, as this inquiry explored, is a very important subject for us to be getting right, to be striking that balance in the best possible way. I will at the outset note that many of the protections are already in place to some degree through disability protections in the Equal Opportunity Act. That does provide a mechanism for some coverage for people, but there is various different case laws, both strengthening and querying that point, and I think it's an area of a gap, or a potential gap, that is certainly well worth careful consideration into. And on that point, I will say that this is something that the government has been particularly interested in and engaged with, both through its response to the inquiry and the ongoing work which I understand is taking place, in fact taking place right now. The government remains committed to strengthening protections for Victorians living with a disability, and indeed protections for Victorians who require medication to perform their essential work. We're also committed to ensuring that the law keeps pace with people's lived experiences, and I think to look for no better exemplar of that commitment, you would find that in the anti-vilification laws, which were passed through the Parliament about a year ago now, and pushed forward very strongly by this government, which for the very first time included the attribute of disability as something in that as well. So whether it be in that space or in the space that we're looking at today, we do have that track record of interest and of delivery and reform in this space, and it's something that I will continue to be deeply engaged with and supportive of as a member of the government as well, having, as I'd said, the privilege to take part in many such previous debates in this chamber. Now, the government does, and this will not be of surprise to other members in this place, but consistent with the convention of not supporting private members' bills, will not be in a position to support this bill today. However, that work is currently being done, as I say, to assess the viability of such a reform going into the future. And I think that anti-vilification is, of course, a very recent example of that reform in this space, but perhaps the most foundational reform that I could refer to is all the way back over a decade ago, when this government did become the first jurisdiction in Australia to first trial and then formally legalise medicinal cannabis as a treatment for Victorians. We saw for a very long time advocates explain their frustration in seeking support and finding that the best medication for them was something that they were legally barred from accessing, and the very real pain, the very real trauma that led to, and indeed the very real consequences that had for workforce participation as well. We have come a long way since that point, and indeed in a debate a couple of years ago I made reference to the fact that some 400,000 prescriptions had at that time been made for medicinal cannabis in the state of Victoria, a figure which I've no doubt has continued to grow from that point. I shared at that time in 2024 a story of a friend who had another friend who was suffering from an epileptic fit. They were driving on the Monash Freeway. My friend had to pull over and had to physically restrain his friend on the nature strip and on the side of the road, and a very dangerous situation, but one which ultimately through medicinal cannabis would find a treatment for, which was life-changing for them. So the medical evidence is clear, and what we can do to improve the experience for people who are undergoing treatment through medicinal cannabis is really, really critical. And I think this draws to another debate that we've had in this chamber, and that does have a lot of interaction with the bill before us today too, and that is the impairment test and how we actually define what is impairment. We know that typical tests don't accurately measure impairment, they just measure presence. And what that means is someone may have taken a substance over a week earlier and be completely unimpaired by it, but they are still having that substance show up in any testing. This, of course, particularly comes to concern when it comes to driving, and I was actually very pleased a couple of years ago to work with colleagues in the LCV party to formulate and refine wording on a motion which actually led to the commissioning of a report by two eminent Victorians, Tony Parsons, who is a former supervising magistrate in the drug court, and Dr Hamish Morrison. Their review, which became known as the Parsons Review, did extensive research into how we can best support motorists who, of course, many would be using medicinal cannabis for very legitimate reasons as well. Engaging with high level, I believe it was 18 stakeholders to get feedback on the best way we could implement legal reforms. There were a few clear paths that came out through, but the most immediate path that was very self-evident was that the system as it was back then was extremely prohibitive, as anyone who was faced with a test result and then faced before a magistrate, that magistrate found themselves with no ability to apply discretion to the case, and in fact would have to then suspend the licence or otherwise impose a restriction on their ability to drive, which of course is deeply unfair in the case of not being able to sufficiently test impairment. So the interim solution, which has since now been legislated by this chamber, was to change that rule to give magistrates that discretion, so that in those cases where someone finds themselves embroiled in that, they can actually have a defence in the magistrates' court, and the magistrates can apply that common sense discretion, meaning that they won't be nearly as likely to have their livelihood impacted. It doesn't change the fundamental issue though, and that's why I've also been very pleased to see the so-called medicinal cannabis closed circuit track trial, which is currently underway in Lang Lang, and I know members, all of us in this place, are very keenly anticipating the results of that trial. Indeed, as the Parsons report outlined, and a quote from the report to say, what became clear during the 18 consultations was a shared desire for more data. And this is something that I hope that can be delivered by the track trial. Indeed, I've had, just as recently as a few weeks ago, but on a number of occasions now, constituents from my electorate write to me about their concerns. People who want to or need to, or for whatever reason, should have the absolute right to be able to drive whilst appropriately managing their medication as well with medicinal cannabis. And it is a genuine concern. And whilst we have update and progress to report through the recent legislative changes, there is certainly more work to do. And this track trial will provide the basis of how we can come to a more accurate test of impairment. That in turn will assist this process as well when it comes to the workplace. And there are, of course, in many workplaces, a direct correlation. Much work does involve driving, be it delivery drivers, be it in the rail industry, in the public transport industry, trucking, commercial passenger transport, or even various other jobs as well, which people may need use of a car for. So there is a direct correlation here, but also a further correlation, a broader correlation in terms of what is impairment as it relates to safe workplace conduct, just as much as it applies to safe driving. I think a further point which is worth just briefly touching on is some other work that the Legal and Social Issues Committee has undertaken in this term, and that is a separate inquiry into the decriminalisation of cannabis. Now, that is certainly not what we are talking about today, but given that we're talking about medical treatments and impairment, that would, in the case of such decriminalisation, will be something that would need to be considered appropriately by government as well. Noting that in the government's response to that inquiry, the government did not support a decriminalisation process. That is something that nevertheless is something that should be, albeit briefly noted, should legislation such as this or this legislation indeed pass. So the situation that we find ourselves in presently, Acting President, as I was saying just a few moments ago, we do find ourselves in the space where the Equal Opportunity Act does in fact cover disability specifically. We've seen comments from Ro Allen, the Commissioner. In fact, I was talking about those comments with the Minister at the table this morning, who has repeatedly affirmed that the discrimination provisions as it pertains to disability does in fact apply to then treatment as well. And we've seen through the submission that the Victorian Equal Opportunities and Human Rights Commission made to the inquiry in fact affirmed that as part of a broader direct or indirect discrimination. This does still leave the gap to a certain degree, but the VROC's submission says under the EO Act, persons with disabilities are protected from unlawful discrimination. Employers also have a positive duty to eliminate as far as possible discrimination, sexual harassment and victimisation from their workplaces. Some exceptions apply that are discussed, namely discrimination reasonably necessary to protect health and safety. The submission goes on to say that the definition of discrimination in section 7.2 confirms that the EO Act protects people from discrimination because of a characteristic that a person with that disability generally has. However, it is not expressly clear in terms of how it may apply to people receiving prescription medication or treatment for a disability. And that brings us to the heart of what this bill seeks for us to address. Indeed, we've had, as part of the deliberative process of this chamber and of this parliament, we also have this Scrutiny of Acts and Regulations Committee, which released its routine regular report just yesterday, including on this bill. And the SARC said to the Parliament that the committee notes that the EO Act prohibits discrimination on the basis of a disability in employment and employment-related areas, education, the provision of goods and services, and the disposal of land and accommodation, and by clubs and club members, and in sport and in local government. Each of these prohibitions, except disability discrimination by clubs and club members in sport and local government, are subject to exceptions in some circumstances, where adjustments required by a disability are either not reasonable or where the person could not perform the employment or derive a substantial benefit from the activity, even if the adjustments were made. Additionally, section 86(1) generally provides that a person may discriminate against another person on the basis of disability if the discrimination is reasonably necessary to protect health or safety or property. One of the central recommendation of the VROC report, the VROC submission to the Legal and Social Issue Committee's inquiry, is providing for reform of the Equal Opportunity Act, and it provides two options from which to do that, of which this bill has selected, I believe, option 1. I think it's important to note that, as in support of this reform, it is something that will see that gap between what is already covered by disability and then what is generally indirectly or implicitly implied through treatment of that disability or other condition, but not directly covered as it relates to the treatment of that condition through the substances, prescriptions, including medicinal cannabis or anything else that a patient may be using. And I note that disability as an attribute is something that this government has been focused on supporting, and indeed, as I mentioned earlier, working with people with this lived experience to make changes to laws as it becomes necessary, and including, in fact, with the anti-vilification laws, which centrally made disability as well as sexual gender identity, sexual orientation, as well as racial and religious attributes, a component and attributable factor under the anti-vilification laws. It's also come up through other reform work to the Equal Opportunity Bill that this government's undertaken, namely the Equal Opportunity Religious Exemptions Amendment Act of 2021. Many of the concerns that relate to this, of course, do come under the VROC responsibility and the Equal Opportunity Act, but it also, of course, pertains to the Fair Work Act, and much of the case law as it comes to this matter has been done through the federally originated Fair Work Act. So the Legal and Social Issues Committee did conduct its inquiry extensively in 2014 into the issue, and as well as submissions from VROC, which I've already referred to, also received submissions from a wide range of stakeholders, including the Police Association, Trades Hall Council, the Pennington Institute, and also the Drug Advisory Council of Australia, who we've seen at a few other inquiries too. The findings and recommendations of that report are relatively straightforward. There are 3 findings that were made, 7 recommendations. Finding 1 in particular goes to the heart of some of my earlier comments, saying that the Victorian government forgive me, that's the wrong quote, but that the tests for presence, not impairment, are not effective at assessing someone's mental well-being or safety in terms of being able to facilitate their work. So the impairment test issue really does come back to needing that reliable methodology that I'm very much looking forward to seeing through other reform and review work that's underway at the moment, and acknowledging that that is the central issue. There are multiple findings, 3 findings and 3 recommendations. Recommendation 3 in particular goes to the heart of what we are discussing today. And that recommendation is that the Victorian Government amend the definition of discrimination in Section 7 of the Equal Opportunity Act to clarify that where a person uses prescription medication or requires medical treatment for a disability, this is a characteristic that a person with a disability generally has. The government's in response to this and in affirming my earlier remarks that this is something that is being actively reviewed and considered by the government at this time. The government's response was that this would be under review, saying that the government is committed to protecting and promoting the human rights of Victorians with a disability, including by recently legislating to expand anti-vilification protections to include the attribute of disability through the Justice Legislation Amendment Anti-Vilification Social Cohesion Act of 2025. Importantly, there are a range of existing legal protections in both Victorian and Commonwealth legislation that may assist people with disability who are experiencing discrimination. That the EO Act, for example, provides protection from discrimination for people with a disability in the workplace and in other areas of public life. It's also noted, and frequently noted indeed through the government's response, that employers also have a positive duty to eliminate, as far as possible, disability discrimination from their workplaces. And this interacts with, of course, the OH&S Act, the Fair Work Act, and the Disability Discrimination Act of 1992, those last 2 being Commonwealth Acts, also providing a range of protections for people with disabilities. It goes on to say that expanding the definition of discrimination in the Equal Opportunity Act to expressly capture the use of prescription medication or medical treatment for a disability does require further analysis, but it's something that it could be considered as part of any future broader reform to the Equal Opportunity Act. Any future reform to the EO Act will require thorough consideration of resourcing and economic impacts to Victorians and comprehensive consultation with a range of stakeholders. So I am very pleased to see that recommendation, certainly not just keeping the door open, but actively committing to further pursuing that work, and indeed as part of future reviews and ongoing work that's already been undertaken by the government, and indeed as part of the bedrock for a future reform. There is also responses to other recommendations in the report, in particular recommendation 1, in which the government supports in part finding about the issues where there is a well-founded belief on employers, and where the issue being with this one, where a well-founded belief could be subjectively misused in some cases by some employers. Indeed, as a former union official myself and someone who has represented workers through AOD screening queries, I would also be concerned about the level to which this broad interpretation as proposed by our committee may be misused by a small number of employers, indeed by targeting based on reasons of personal prejudice or performance rather than on observed attributes or observed behaviours. Nevertheless, it is something that is worthy of consideration in how we can get that appropriately done. Further recommendations such as WorkSafe, conducting and providing updated advice on alcohol and other drug management policies would be certainly very useful as well, and that has received support of government through its response to the inquiry recommendations, as well as WorkSafe. Investigating impairment testing methodologies as well to provide that further work and further support. And indeed the recommendation 7, which does also go to reference the closed track trial, being supported by WorkSafe and what WorkSafe can do to continually review the new and emerging evidence, particularly through that trial, but certainly not exclusively through that trial, and through best practice cases from overseas as well, and how that can inform better advice from WorkSafe to employers, to unions and to workers as well. So there are, as the inquiry went into, a number of key pieces of legislation that this bill, that this issue pertains to, and interestingly, of one of the key pieces outside of course, the Equal Opportunity Act is the OH&S Act, which is one of the other key pieces guiding obviously the work cover system, but also general occupational health and safety across Victorian workplaces. There is, and this goes to the shared duty of reducing and eliminating risks, and this of course includes the role of HSRs, which are a very important part of a healthy workplace culture. Employers having a duty to maintain a safe working environment and to take reasonable care for the safety of their staff. Interestingly, there is actually only one sector under the Occupational Health and Safety Act that is specifically called out for in relation to alcohol and other drug testing, and that is the mining industry, which is of course relatively minor industry in our state as compared to most. There are certain provisions in the Act through how the mining industry must comply with its obligations when it comes to AOD testing, and indeed how that operates. The Equal Opportunity Act itself, as we've already been through extensively, as well as the Charter of Human Rights and Responsibilities, the various agency acts, including both IBAC Act and the Victoria Police Act, provide directions and guidance in how this testing can be conducted in relation to serving officials and serving officers, including that directions to take a test cannot be refused, and sets out appropriate frameworks and parameters, including that the circumstances in which tests may be directed to be taken, such as if a serving officer is involved in a critical incident due to reasonable suspicion that they may have been affected by a drug of dependence or alcohol, if they appear to be unfit for work, and indeed through some limited provision for random testing as well. The broader application of these rules would come through three other acts, that being the Bus Safety Act, the Commercial Passenger Vehicle Industry Act, and the national law from South Australia, which is the Rail Safety National Law Act, in terms of rail safety for people involved in the direct and related operations of railways and other transport industries across the country. And interestingly, between these various different acts, there is some variance in timelines and requirements for different workers as well, all of which was explored in the inquiry. The Equal Opportunity Act amendments would effectively apply a consistent approach of protection, even if further detail would be resolved through regulations in that or other pieces of legislation. There are certain case studies, and I understand that my colleagues in the LCV party have discussed some extensively already, but indeed in relation to specifically medicinal cannabis and case studies of its application in various Fair Work cases, I believe, all from other states, but in relation to Hague versus Platinum Blasting Services, in relation to Miller versus FQM Australia Nickel, and Sharp versus BCS Infrastructure Support, has generally been held that use of medicinal cannabis where it has been legally prescribed has been accepted and upheld in Fair Work cases, although in one particular case it was found that the employee's failure perhaps a stronger word, but the fact that they hadn't notified their employer of their prescription prior to the offending test had worked against them in that decision. So this is another area where, albeit where it applies to interstate example under the National Fair Work Act, this is something that the provisions under the EO Act that this bill seeks to address could certainly apply. And indeed, from my time as a union official previously and supporting members through AOD findings, albeit not a significant occurrence in the retail industry, but as it comes to the role of delivery drivers, and Acting President, you would know all too well about these issues and concerns, and the importance of proprietary and making sure that the testing regimes are fair and are not used as a punitive measure on the personal whims of a small number of managers who are seeking to use it for purposes outside of what a reasonable testing regime would seek to achieve. There are various other aspects that this government is committed to and ongoing work in this space as well, of course, and I'll park the obviously contributions that the state makes to the National Disability Insurance Scheme, indeed the State Disability Plan, which is due for renewal this year and which consultation is to be commencing on very shortly as well. There is certainly ongoing work, as I've pointed to already in this contribution, about what is being done and what the track record of this government is to achieve meaningful progressive reform. Again, coming back to the fact that this was the first state in the country to bring in a medicinal cannabis, first through the trial, then through legislation, and we have seen the transformative impact it absolutely has. As we have this system, of course, it's really important that we are providing the safety for people to take medication which is supporting them, which is in many cases helping them to actually function, and not holding unfair pressures or standards against them. And it goes to the very fundamental right that people have to be able to work and to have their dignity, but it also goes to a level of status and understanding that for example, medicinal cannabis, but indeed any other type of prescription medication that someone may need to take, provided it does not interfere directly with the safety of their work, is not something that should be in any way viewed as less than or as something that's less worthy of consideration. And the more that we can reform these laws, whether it be through the space of driving, as we've already done in some interim fashion, and as more work needs to be done, or indeed as it comes to supporting workers in the workplace so that they've got those protections there, the less of a stigma is attached as well, and the more important, the more they can fully contribute freely without that fear of discrimination and of being viewed or treated differently, especially in the most extreme sense, but also very importantly in the day-to-day sense as well, that the work that we can do in this place can set the groundwork for that cultural reform as well. So whilst the government's policy remains not to support private members' bill, I do point to the fact that we have a clear legislative track record of support of sensible common sense reform in the space of medicinal cannabis, and I certainly look forward to seeing the outcomes of the work that is being undertaken on this very issue, and indeed of working with colleagues in the Legalise Cannabis Party to ensure that all Victorians have the right to access their treatments, to access care that allows them to function and be the best version of themselves in society, and I'll very much continue to look forward to seeing that work take place.
Thank you, Mr. Galea. Mr. Mulholland.
Thank you, Acting President. I rise to speak on the Equal Opportunity Medical Treatment Bill Amendment to Medical Treatment Bill 2026 as proposed by Mr Eddershank in the Legalise Cannabis Party. And I respect that Mr Eddershank has brought forward this bill, and having read his second reading speech, know that he does so earnestly with passion and goodwill and intent. However, the Liberals and Nationals will be opposing this bill, and I want to take a small amount of the Chamber's time, much smaller than Mr Galea's, to explain why. The Equal Opportunity Act contains a very broad definition of disability, which captures many of the scenarios described. This bill risks duplication and legal confusion rather than clarity. Our main concern, however, is the risk that continually adding subcategories of protected attributes creates a never-ending expansion of the Act. An activity is not a protected attribute. If medical treatment is carved out, you have to ask what comes next. I am a St Kilda Football Club fan, a long-suffering one at that. And you have to ask, will that eventually be a protected attribute too? The Equal Opportunity Act rightly prohibits discrimination based on specific personal characteristics and attributes. These include age, gender, race, marital status and disability, and there are several more. We strongly support these protections, including the absolute equality and protection of people with disability, though we understand the sentiment of the bill. We support the protections that are in law. We would be concerned that if we extend these protections to certain actions or behaviours, it could unintentionally imply that other actions or behaviours are not protected. We strongly support a complete protection of equality for people with disability, full stop. However, this bill risks turning the Act into an overly complex and unworkable piece of legislation. The bill is well-intentioned, but I think poorly targeted. It adds complexity and legal risk while delivering uncertain and duplicative protections for that already largely exist in law. So the Liberals and Nationals will not be supporting this bill.
Mr Öftra.
Thank you, Acting President. I also rise to make a contribution on this bill, the Equal Opportunity Amendment Medical Treatment Bill 2026, which has been brought to the Chamber by Legalise Cannabis Victoria, and the government's position on this bill should come of no surprise to anyone in this chamber, but the government does not support private members' bills. It's a matter of convention, and this specific issue requires further consultation across the community and legal sectors, but overall the issue is worthy of discussion. I'd like to thank Legalise Cannabis for their advocacy on this topic, if not anything other than consistently have advocated for law reform in regard to medicinal cannabis, because people who may be suffering from chronic pain and the like might avail themselves of medicinal cannabis, and of course that has some implications for people who may drive their cars and may be pulled over by Victoria Police. Now, my understanding is, and I've heard my other colleagues in the chamber make their contributions and touch on this issue as well, there currently does exist for anybody who is a medicinal cannabis user, if they are roadside drug tested and the like, that they can then go to a magistrate's court to have that matter reviewed. But I understand that Legalise Cannabis are wanting to do more than that. Again, it is a fraught situation and nobody wants to be, pulled over and potentially fined and the like for taking a substance that is there to help deal with chronic pain and the like. However, there are issues around that, and I know we've in debates on these matters before, we've talked about what is impairment, what does impairment look like, and to my knowledge, around the world there is still no adequate test that determines impairment. And likewise, that's why when you look at, blood alcohol content testing, a figure of 0.05 was arrived at. And again, we know that impairment levels can vary widely for people, even if they're under 05 and drinking alcohol. It is a very vexed and tricky topic. And as I said, particularly on this particular issue for cannabis, there's no international standard for determining impairment. So it's inherently difficult. But nevertheless, I acknowledge Legalise Cannabis's advocacy on this topic, and again, this bill has largely come out of the Legal and Social Issues Inquiry into Workplace Drug Testing, which was also championed by Legalise Cannabis. As I said earlier, Acting President, the government's position is, as always, on a private member's bill. The government does not support private member's bill, and we will be opposing this bill. But again, we're always committed to strengthening protections for Victorians who may have a disability, and we want to make sure that the laws keep pace with individuals' lived experiences. We're constantly looking at how we can improve things and make sure the laws are reformed to an extent that keeps pace with modern circumstances and challenges. But we've taken deliberate steps to strengthen Victoria's equal opportunity framework over time, including reforming religious exceptions and expanding anti-vilification protections to include disability. And the Allen Labor government recently legislated to expand anti-vilification protections to include the attribute of disability through the Justice Legislation Amendment, Anti-Vilification and Social Cohesion Act of 2025. Now, this is legislation which the Liberal Party and their One Nation partners actually opposed as well. But the Equal Opportunity Religious Exception Amendment Act 2021, which commenced in 2022, narrowed the scope of religious exceptions introduced in 2011, and that means that religious bodies and schools can no longer discriminate on a wide range of attributes in key settings, and discrimination in government-funded services is now significantly restricted. So these reforms demonstrate the government's commitment to strengthening protections in a considered and targeted way, and we recognise that people with disability should not face discrimination because they are accessing prescribed medication or medical treatment. So, Acting President, it was a Victorian Labor government who delivered stronger protections under the Equal Opportunities Act of 2010, which prohibited discrimination on the basis of disability, including characteristics associated with disability. Now, these protections provide an important foundation, including protections relating to characteristics associated with disability. So the definition of discrimination in section 7 subsection 2 makes clear that the Act extends to characteristics that a person with a disability generally has. It is arguable that this already captures circumstances where a person requires prescribed medication or medical treatment. Now, at the same time, we recognise that the law must continue to evolve, as I'd said earlier, and we are actively considering how best to ensure it reflects the realities of the prescribed medication environment and treatment for people who may be living with disability. There are a range of existing legal pathways. As I said earlier, like I said, if you were pulled over on the roadside, you were issued with an infringement or whatever, there are ways to have that reviewed in the Magistrates Court. But also, employers have a positive duty to eliminate, as far as possible, discrimination in their workplaces, including discrimination on the basis of disability. So, as was said, the government response to the inquiry into workplace drug testing expanded the definition of discrimination in the Equal Opportunity Act to expressly capture the use of prescription medication or medical treatment for a disability that requires further consultation and analysis and consideration of the resourcing and economic impacts on Victorians. Now, it's not a question of whether protections should exist or not. It is about ensuring that any changes to the law are clear, workable, and do not create unintended consequences. Now, at the same time, Acting President, I am mindful that some industries require robust drug and alcohol policies to ensure the safety of employees and the broader community. Of course, anybody in a workplace who might be working with heavy machinery and equipment, there are drug testing, obviously, that happens in those working environments, and some of these environments are inherently dangerous, and working with heavy plant equipment can be inherently dangerous. So there absolutely needs to be a balance, a delicate balance that is struck. But nevertheless, our governments have demonstrated our commitment to strengthening protections through recent reforms that, as I said, expand anti-vilification laws to include disability. So it's a challenging environment. There are, and we talk to industry all the time about what their needs are, and you only have to look at a wide array of decisions that have come out of the Fair Work Commission about workers who have been impaired through drug or alcohol usage in construction environments, but also whether it's professional driving environments like trucking and the like, or rideshare, any of those environments where someone may be affected or impaired by substances that they take. Because, Acting President, these things have real-world consequences, and might be something for one person to take something to alleviate pain that they might be experiencing due to a chronic pain condition. But there is still an inherent risk to other road users and potentially to other people in workplaces who they may be working with. And these are some of the things that need further consideration, careful consideration. Now, I'd also like to thank and acknowledge the many organisations who made submissions to the Legal and Social Issues Committee inquiry where these reforms sort of emanated from. So, at the time, there were submissions from the Drug Advisory Council of Australia, the Police Association of Victoria, the Victorian Equal Opportunity and Human Rights Commission, the Australian Industry Group, the Pennington Institute, Victorian Trades Hall Council, and Harm Reduction Australia. All of those organisations obviously have an important role and stake in this matter, and made very considered contributions and submissions to the inquiry. And as I said, this bill is larger than it just being about medicinal cannabis. But it is also important to note that Victoria is a leader in medicinal cannabis as well. In 2016, Victoria became the first Australian state or territory to legalise medicinal cannabis under prescription for therapeutic uses. And I know many people in my electorate who emailed me at the time when we were doing this, and later on when there's been further discussion around this, talked about the importance of this to them. But again, it was all done in a very carefully and considered way. Now, in terms of the legalising medicinal cannabis, originally this was a commitment that Victorian Labor took to the 2014 election, and we have in fact delivered on that commitment. As I said, it was followed by the 2015 release of the report of the Victorian Law Reform Commission on how to amend the law to allow people in exceptional circumstances to safely access medicinal cannabis. And as I said, it has been a game changer for many. Now, the Allan Labor government believes in equal opportunity for Victorians with a disability across areas in which they live, work and play, and we provide for disability inclusion supports in our schools, a reform which was delivered by this Labor government to provide practical infrastructure supports in kinders through building blocks inclusion grants, and many of us have seen some amazing inclusive play spaces that have been delivered as a consequence of those building block inclusion grants. It really has been game-changing for kids to be able to play in some of those spaces. And we also support Victorians with disability with transport assistance through the multi-purpose taxi program, and I know Mr Barton, who was a member in this place, advocated strongly for those reforms as well. And also when it comes to the NDIS, Acting President, one of the greatest social reforms this century was delivered by a Labor government, and the Allen government is providing a $3.2 billion contribution each year to that as well. So for Victorians with disability that need specialist disability accommodation as well, the Allen Labor government is one of, if not the largest provider of specialist disability accommodations in Victoria. And importantly, we're ensuring these buildings are fit for purpose through building 27 new homes, 19 have been completed so far, and a further 8 are under construction. So we recognise that equal opportunity for Victorians with disability needs to be a priority, and we take a whole of government approach to that. And that's why we're commencing consultation shortly on the next phase of the Victorian State Disability Plan, which follows success of Inclusive Victoria, which was the State Disability Plan 2022 through to 2026. Now, at the midway point of the current State Disability Plan, the vast majority of actions outlined in that plan are either completed or on track, and some of the completed actions and achievements include the appointment of a Chief Accessibility Advocate within the Department of Transport and Planning, endorsement of the National Principles for the Recognition of Assistance Animals, Sport and Recreation Victoria's Together More Active program, which invested $1.74 million to support 15 inclusive participation or workforce development projects. The disability liaison officers in hospitals who have responded to 37,500 referrals from people with disabilities seeking support to access healthcare. The government funded the Mental Health Interface program to strengthen the interface between consumers, mental health inpatient services and the NDIS, which is critically important. And Homes Victoria is using best practice universal design principles in social housing as well. 34 specialist disability practitioners are supporting families with disability access to the NDIS and necessary supports. And also, Acting President, Emergency Management Victoria created a senior advisor for accessible communications role to support accessible public communications in emergency preparation, response and recovery. So you can see some very well thought out actions arise from that plan, and our government has consistently and steadfastly been working through implementing all of those actions to ensure that Victorians living with a disability are able to feel more included and inclusive in a whole range of services. Also, Family Safety Victoria has embedded universal design, disability, confident and inclusive workforce into its policies and programming, planning for people with disability and their families who are victim survivors of sexual violence as well. So I could go on, Acting President. There are still many more reforms that this government has done. But again, I just note that, our position is on private members' bills. We don't support them. This specific issue requires much further consultation and more detailed engagement with the community and legal sectors. It is a vexed issue, but nonetheless, I thank you, and I'll conclude my contribution there. Thank you.
Thank you, Mr. Ms Payne.
Thank you, Acting President. I rise to speak on the Equal Opportunity Amendment Medical Treatment Bill 2026, introduced by my colleague David Eddershank in relation to medical treatment for disabilities and for other purposes. And I think I might just start today by acknowledging some of the contributions in the chamber, because it seems as though not many people who are contributing on this bill have actually read the bill. Because we're not talking about attributes and adding further attributes to the Charter. What we're actually talking about is amending part of the Charter that is already there and already provides coverage for disability, and adding a part to that for clarification purposes. So the conversations that I've heard across both sides of the chamber around attributes and adding further attributes to the Human Rights Charter are not correct. This is actually a referral that has come from the Human Rights Commissioner themselves, and what it states is that we need clarification around that definition of what disability is, and that would include access to your medication as part of that attribute. So the intent behind the Equal Opportunity Act is simple: to make public life free from discrimination. The Act recognises that discrimination causes real harm. It affects all aspects of public life, from employment to education to transport to commerce. It erodes real-life opportunities and has a terrible impact on the mental and physical health of individuals and entire groups. Worse, the greatest burden is borne by those with the least power and opportunity. Ending discrimination remains an important human rights issue. The Equal Opportunity Act is about reducing that burden and enshrining the fair go for all Victorians. Further, it is proactive. In fact, the Equal Opportunity Act includes a positive duty to eliminate discrimination. And we have that opportunity today to end discrimination against Victorians for simply taking medicine prescribed by their doctors. And I make reference to that term medicine prescribed by their doctors. This bill is not explicitly about medicinal cannabis, although obviously as a prescribed medication that would be covered. But again, contributions today allude to the fact that this is a protection based on medicinal cannabis, which is not the intent of the bill. The intent of the bill is to provide protection based on medication you take in support of your disability. To be honest, it beggars belief that we are even having this discussion in 2026. I think it is fair to say that almost all Victorians take some form of medication for something. If they don't currently, they are likely to have to at some point of their lives. Advances in medical science mean that we have access to incredible and life-changing medications and treatments. These range from over-the-counter paracetamol for headaches, to prescriptions, statins for cholesterol, to antibiotics for flus, to chemotherapy for cancer. It's not too long ago in human history that dentistry was performed without anaesthetic. Can you imagine? Painkillers consisted of alcohol and hope, and that people died well before when necessary in acute pain from diseases we can now prevent and or manage. Advances in medical science are good, but we all know that some medications are more socially acceptable than others. And as a Legalise Cannabis MPs for Legalise Cannabis Victoria, we can assure you that not all drugs are treated equally or without prejudice by the law. Medications associated with lesser understood or even taboo conditions, things like mental health, sexual health, pain, addiction and so on, are still heavily stigmatised. Victoria proudly led the way as the first state to legalise medicinal cannabis in Australia, but there is still stigma due to misinformation and the prohibition of cannabis more generally. This stigma exists in the media, the law, and to some extent in medicine. It is immature and outdated. At times, people even joke about it. I can assure you that being fired from your job for taking medicine that helps you is no laughing matter. Being denied housing, goods and services, access to clubs, volunteering and education and are similarly serious and life-changing. We have case studies and numerous real-world stories from people who have experienced discrimination for taking prescribed medicine. Now, many of you will know elite athletes like Lauren Jackson, Damien Oliver, and AFL coaches Damien Hardwick and Alistair Clarkson, who have all spoken out about discrimination they have faced as medicinal cannabis patients. And for what? Taking medications recommended to them and prescribed to them by their doctor that help them? But this isn't about well-known personalities or celebrities. This issue affects everyday Victorians and it destroys lives. I would like to draw your attention to a couple of examples in a bit more detail. Angelina is a woman in her late 30s. She was offered her dream job through a national disability employment program that placed her with a major Australian organisation. Disability is one minority that can be acquired at any point. We can, and likely will, all be part of a disability community at some point, whether by injury, illness or age. Angelina became a person with a disability in 2019 when her right arm was injured at work. This led her to develop complex regional pain syndrome, or CRPS, and has been described as one of the most painful conditions in the world. The pain is unpredictable and debilitating. At first, Angelina managed the pain with opiates, which caused significant side effects. Then she was prescribed medicinal cannabis to replace them. Angelina worked full-time until she was injured, but after that went back to university to retrain. She is now a high-achieving master's student. After some time, she found a new job that aligned perfectly with her studies and previous work experience. Angelina disclosed her disability during the interview process and formally accepted an internship. At this point, she let the company know that she was taking legally prescribed medicinal cannabis to manage her pain. She asked whether this would be an issue and what their policies were. The job did not require any driving. She completed every check required by the company doctor and showed them her prescription. Then, she never heard from them ever again. Communication didn't just slow down, it completely stopped. Angelina reached out multiple times and sought an explanation. Only much later, through indirect communication she pursued via the Disability Employment Program, was it confirmed that the outcome related to internal policies about drugs and alcohol. Now, this is blatant discrimination. Rosemary has a similar story for a different medication. Rosemary lives with severe chronic conditions that require medication. She is a co-leader of an arthritis support group and works for a patient organisation. Many people with various forms of arthritis rely on opiates for pain relief, with or without other medications and interventions. Most of these do so under the regular supervision of their treating doctor. However, many report discrimination from health professionals, such as emergency staff, because of their need for opiates. Many feel like they are treated like drug addicts. The fastest growing group of medicinal cannabis consumers is older people living with chronic pain. Women in general are the second largest group and are using it for anything from endometriosis to menopause to insomnia. Medical discrimination crosses all barriers, but the people most likely to suffer often face multiple layers of compounding discrimination. And to be frank, if you're white, middle-class, able-bodied mum from the suburbs, you're far less likely to show up to emergency and be denied pain relief on the basis that you might look like a drug addict, or to be drug tested at work, for instance. People with disabilities, First Nations people, trans and gender diverse people, younger men, we hear many and varied stories about them not being believed in healthcare settings, at work and elsewhere, simply because they fit an outdated stereotype about drugs. I could cite many more examples, and I'm sure all of us know someone with or who has experienced chronic illness and/or a disability. These are real people with real lives, and the best possible outcome for them and for society is that they remain vibrant and active in work and in the community. The Victorian Human Rights and Equal Opportunity Commission agrees. In its submission to the Workplace Drug Testing Inquiry, VERIOC, a body known for their measured and fair approach, has called for medication discrimination to be rectified. It recommended that the Equal Opportunity Act be amended to the following. If a person is taking prescribed medication or receiving treatment for a disability, this is taken to be a characteristic that a person with a disability generally has. In other words, treatment for a disability cannot be separated from the disability itself. To be clear, we are currently in an absurd situation where, for example, someone could have ADHD. Discriminating against them is unlawful. But if they take their medication for ADHD to allow them to function to do their job, they can be discriminated against. In effect, we won't fire you for having ADHD, but we will if we don't like the medication you're on, which ironically enables them to work in the first place. Similarly, a woman trying to conceive cannot be discriminated against for trying to get pregnant, but if she's undergoing IVF treatment, her employer can object to the medication. Someone with a back injury or PTSD or migraines can be fired for the condition, but yes, can't be fired for the condition. But if they use opioids and yes, medicinal cannabis, they can. As Legalise Cannabis MPs, we hear this story time and time again. Other people are unjustifiably and unfairly discriminated against in all sorts of settings. In the submission mentioned above, Verioc drew some specific attention to the need for prescribed medications to be protected. They said the Commission receives multiple complaints of the same nature every year for a range of medications. For this reason, and it is critical, they recommended that the taking of prescribed medication itself be included as a characteristic of the person with a disability. In other words, it's not enough to imply the protection. The status quo is not working. The protection must be spelled out and the loophole must be closed. Verioc went on to say that for the avoidance of doubt, the explanatory memorandum could give examples including medical marijuana to support interpretation of the provision. The advantage of this amendment is that it would clarify that a person who takes prescribed medication or receives treatment for a disability is protected from unlawful discrimination. The key words here are protected and unlawful discrimination. Medicinal cannabis is lawfully prescribed in Australia to almost 700,000 patients. It provides immense relief to tens of thousands of people, many of whom have not found relief with other medications. And I repeat, it is a medication prescribed by a doctor. We are talking about veterans with PTSD, construction workers with workplace injuries, athletes with chronic pain, women going through menopause, and people going through cancer treatment who can't eat or sleep. They are medicinal cannabis patients and they deserve dignity, not discrimination. One issue that MPs have raised with me in relation to this bill is impairment. I respectfully say that many people are ignorant on this issue, and they are certainly not more qualified than doctors. For starters, the Occupational Health and Safety Act 2004 already ensures that no one is at work while impaired. All the necessary carve-outs are already there for operating heavy machinery, vehicles, and for performing any tasks that would in any way be affected by medications. We're not talking about that. We're talking about a teacher who takes medicinal cannabis for menopause so she can sleep the night before. About a student who takes Ritalin to be able to study. About a job applicant who discloses that they use low-dose opioids for an old knee injury. I remind the Chamber that the Equal Opportunity Act provides a positive duty to end discrimination, and we all have that opportunity today. The best possible outcome for all Victorians is that they can live and work without discrimination. This is doubly important for people with disabilities, including chronic illness, who have been left on the margins for too long. Inclusion isn't just a buzzword, it should be practice. To deny the changes we are asking for is to support and uphold discrimination. For those of you who do that today, I beg you, as do people with disabilities, their families and their advocates, to stop talking about a fair go and Victorians doing it tough. There are few people doing it tougher and more in need of fairness than Victorians in pain with disabilities and who are very unwell. It is our job to protect them and their fundamental human right to access treatments that work for them without fear of discrimination. Thank you.
Ms Crozier.
Thank you very much, Acting President. I rise to speak to Mr Eddershank's bill that he's presented to the Parliament in the last sitting week, but which we are debating today. And I want to thank him for reaching out to the Liberal and Nationals to explain the situation and very genuinely has put the case. And I've said to him on a number of occasions, you know, I was in here listening to his contribution and I thank him, and I've got his contribution here. I've marked up some of the very relevant points that I think Mr Eddershank made in his contribution. And as we were speaking before, I wanted to just clear up one thing, because we were talking about the submission made by the VEROC, Victorian Equal Opportunity and Human Rights Commission, to the inquiry into workplace drug testing in Victoria. And as he was pointing out to me, and I just wanted to clear this up because I think there were two options that were put, and as he said, the option one, amending the definition of discrimination in section 7 to clarify that where a person uses prescription medication or requires medical treatment for a disability, this is a characteristic that a person that disability generally has, and that's what this bill addresses or aims to address in terms of amending the Act and to acknowledge that, rather than the second option, which I think, and which I know my colleague spoke of, which was adding a new attribute to Section 6, such as prescription medication or medical treatment, where that confusion may have occurred. And I want to thank him for pointing that out and seeking that clarification. I'm very happy to seek that, to put that on there, which you've described, and that any confusion that may have been had in the House. Now, in that important inquiry, and before I get to that, Ms Payne also mentioned Lauren Jackson, and what a magnificent sportswoman she is, and what a great ambassador for her sport and for our country. And indeed, I've seen her in here, and we've had that opportunity many times. And her story is a very powerful one, there's no question about that. Years of injury from basketball, and as she describes, it didn't end the way I wanted to go. I wanted it to go. There were highs and some pretty big lows as well, and she went under countless surgeries during her career and often resorted to painkillers. And in this article that I'm referring to, that the ABC wrote in December 2021, the chronic debilitating pain around her knee, hip and lower back continued to plague her after she retired. Now, at that elite level where you are subject to some pretty significant injuries with a sport like that, I know when I played netball, I've got, certainly suffering my pain ankle and fingers, no question, but nothing to the extent of what Lauren Jackson sustained. And she was then in that cycle of those painkillers, managing her very chronic pain, her very real chronic pain, and then she was prescribed medicinal cannabis to assist with that. And it worked, and it got her off those painkillers. And, I think there is a huge benefit in this, and I have said it before, and I want to, and I know that you're very strong advocates on behalf of that, and I do believe there is a very great role to assist people with their chronic pain, and cancer treatments and other areas of pain that people might sustain. And when you're talking with this bill, looking at the disability and how that can be applied, so having a look at some of those areas. I do note that in the submission, in the inquiry, it does say the committee also considered the question of discrimination against employees using medicinal cannabis. This is a difficult question to answer, as there is some complexity around whether workers being sanctioned for using medicinal cannabis are being discriminated against under the Equal Opportunity Act or Disability Act. And there is, in the VROC submission, there is a case study of that very example, and it was hard. The employee has dismissed the employee, the employer dismissed the employee for saying they were using medicinal cannabis, and for whatever reason, in terms of their ability to drive or the issue that they had around them potentially not being safe, they're driving in the company, and their responsibility as an employer. I think that's probably where that complexity is, and this Parliament has put in manslaughter laws. I mean, this government has said that the employer has a responsibility to their employees if they don't provide a safe working environment. And I do have some sympathy, for both sides here because of that complexity and the responsibility that employers have. And I equally understand the issue around the discriminatory component that has been highlighted in this. The inquiry report goes on to say employers can dismiss or discipline employees who can't comply with an AOD policy or whose test results contravene the policy. The complexity arises because, as noted in Chapter 2, legislation provides protection against discrimination on the grounds of disability. A person with a disability may be prescribed medication for that disability, including medicinal cannabis, which the committee heard provides some level of protection under the EOA and DA. And so that's what the committee heard, and And they also went on to say that they do accept that there are checks and balances, that the EOA and DA and unfair dismissal laws, that is the Fair Work Act 2009, as shown in the cases included in the chapter of the report, as they highlight, do provide some protections for employees and guidance for employers. Because I do think those protections are there, and we need to manage this carefully. And I know that there was a study that came out just recently on medicinal cannabis, and that was highlighted in various media outlets just in the last couple of weeks, or last 2 weeks. And it is a study by the University of Sydney, the Sydney Matilda Centre, published in The Lancet, which is the largest ever review of its kind, found no evidence for cannabinoids as an effective treatment of depression, anxiety or PTSD. Now, that's not physical issues like Lauren Jackson had. They are saying that the evidence suggested that there was no, it could be beneficial in some certain health conditions, but no evidence for mental health disorders fall short. And therefore, this is one of those contentious areas, I'd suggest. But again, you've got to look at what is the studies and what we're being presented with, and how, therefore, these may be then assessed and interpreted by people with disability, and what form of disability they actually may have. So I do think it is a very complex area. I note that, in this very area where this area where they were looking at the evidence and saying that it didn't have the evidence, they couldn't get to see that there were benefits. And in fact, they also said from the research that THC can cause anxiety, may lead to cannabis use disorder and mental health issues such as psychosis in sensitive people. And we do know that. We actually absolutely know that happens, and we must be very cognizant and aware of those issues with some people that are sensitive. And the President of the RACGP, in response to this particular study, said in most cases there are alternative evidence-based therapies which remain more appropriate, effective and better understood. So I think, as has been said by the peak stakeholder groups like the AMA, RACGP, they know that medicinal cannabis has a role to play. They're not saying that at all. But there is more evidence coming in through these studies that are being conducted, and we need to be looking at that. I just wanted to put that on record because I do think there is some areas that need more work, and despite the submission from the Equal Opportunity, VROC, into the inquiry, there does need to be some more work in relation to this very important area. So I did want to put that on record to say that there does need to be more work in this area. I think there is more evidence coming in. I do understand the intent of Mr Eddershank, and I want to thank him for the really good engagement that we've had, and I understand why he's presented this bill. I understand the reasons why. I understand his strong advocacy for wanting to do this as well. But I do believe that there are some safeguards in place now, and certainly more needs to be done in relation to the research for certain conditions, and that includes the many Victorians with a disability who should understand the reasons for decisions that are being made by government. So, with those words, President, I will conclude my contribution because I know others do want to speak on this important bill. It is an important bill. It is an important debate, and one that, again, I want to thank Mr Eddershank for bringing before the Parliament.
Ms Gray-Barbera.
Thank you very much, President. I'm pleased to speak on behalf of the Greens to support the Legalise Cannabis Party's bill today, the Equal Opportunity Amendment Medical Treatment Bill 2026. The aim of this bill is simple: to end the discrimination against people with a medical condition who access medical treatments or take prescribed medication to treat that condition. This bill amends the Equal Opportunity Act 2010 to expand the definition of a registered health practitioner and clarify that discrimination includes treating someone unfairly because they use prescription medication or require medical treatment for a disability. This comes after the 2024 inquiry into workplace drug testing in Victoria, with the final report recommendation 3 calling on the Victorian Government to amend the definition of discrimination in the Equal Opportunity Act 2010 to clarify that where a person uses prescription medication or requires medical treatment for a disability, this is a characteristic that a person with that disability generally has. This recommendation by the Legal and Socials Committee during the inquiry could make a real difference for many people who are currently facing discrimination based on the type of prescription medicine they take. We know so many never proceed with complaints of their treatment because of time, lack of understanding of processes and the systems, and many other barriers. This Allen Labor government has sat on this recommendation for nearly 2 years. In their government response to the inquiry in November of 2025, they talk about any reforms to the Equal Opportunity Act 2010 will require thorough consideration of the resourcing and economic impacts on Victorians and comprehensive consultation with a range of stakeholders. However, we know from history when this government is motivated to make change, it happens. And this amendment put forward in this bill by the Legalise Cannabis Party is sensible and is supported by many stakeholders who engaged through the inquiry process. It's been 11 years since medicinal cannabis was legalised in Victoria, and thousands have been prescribed this treatment. It is the Greens' position that someone with a medicinal cannabis prescription should be treated the same as anybody else with any other medical prescription. It's about time our laws keep up with the reality for so many Victorians. No one should experience discrimination for following doctors' orders. People using medicinal cannabis for relief from pain and suffering should be given proper access to this clinically proven treatment. Stigma should not stop people from accessing medicine or penalise those who use it. If we are serious about drug harm reduction, we must turn our focus to impairment and harm. Any medication that causes impairment should be taken seriously. But when people avoid taking prescribed medicines due to fear of discrimination and judgment, their symptoms worsen, and this can cause greater impairment and further health risks. We must shift to a health-based approach towards drug use. This accepts the reality that many in our community use drugs. It's the first essential step to reducing drug harm. We must stop the discrimination. I commend this bill to the House.
Ms Watt.
President, thank you very much for the opportunity to rise and make a contribution, and for confirming just then that I will indeed have an opportunity to do so. And I do that following the contributions of Ms Payne and Mr Edershank, and who I on odd occasions just refer to as my neighbours. And I know that this is a bill that is enormously important to them and their agenda as members of the Legalise Cannabis Victoria party. The Legalise Cannabis Equal Opportunity Amendment Victoria Medical Treatment Bill 2026 is a bill that is largely born out of the Legal and Social Issues Inquiry into workplace drug testing. Now, I just think it's perhaps worth putting on the record that whilst I am currently a participating member in the Legal and Social Issues Committee, this inquiry was conducted before I was able to join, and so I can't speak with considered contributions about the work of that inquiry, but to say thank you very much to the members that participated in it, and know that the inquiry itself was something championed by my colleagues here. I'd also like to take a moment to acknowledge the diverse range of organisations that contributed submissions to that committee inquiry. The breadth of perspectives provided was essential to understanding truly the complexity of this issue from really every angle. And can I just acknowledge the Victorian Trades Hall Council, the Victorian Equal Opportunity and Human Rights Commission, the Police Association of Victoria, the Pennington Institute, AI Group, the Drug Advisory Council of Australia, Harm Reduction Australia, and medicinal cannabis reform. I do understand the position of the Legalise Cannabis Party. However, the Chamber will be aware that as a matter of convention, the government does not support private members' bills and therefore will not be supporting the bill before us today. However, we are always committed to strengthening protections for Victorians with disability and ensuring that law evolves and keeps pace with people's lived experiences. And this debate truly does give us a sincere opportunity to have a discussion on the issue of medical treatment, because that issue is certainly a worthwhile one. The government is undertaking the work to assess the viability of such reform into the future, and has taken deliberate steps to strengthen equal opportunity frameworks over time, including reforming religious exceptions and expanding anti-vilification protections to include disability. And we recently legislated to expand anti-vilification protections to include the attribute of disability through the Justice Legislation Amendment Anti-Vilification and Social Cohesion Act 2025. This is a crucial and critical piece of legislation that the Liberal Party and their partners, One Nation, shamefully opposed. The Equal Opportunity Religious Exemptions Amendment Act 2021 commenced in 2022, narrowed the scope of religious exceptions introduced back in 2011. This means that religious bodies and schools can no longer discriminate on a wide range of attributes in key settings, and discrimination in government-funded services is now significantly restricted. These reforms demonstrate this government's commitment to strengthening protections in a considered and targeted way. We recognise that people with disability should not face discrimination because they are accessing prescribed medication or medical treatment. It was the Victorian Labor government who delivered stronger protections under the Equal Opportunity Act 2010, which prohibit discrimination on the basis of disability, including characteristics associated with that disability. These protections provide an important foundation, and the definition of discrimination in Section 7.2 makes clear that the Act extends to characteristics that a person with a disability generally has. It is arguable that this already captures circumstances where a person requires prescribed medication or medical treatment. And at the same time, we recognise that the law must continue to keep pace, and we certainly are considering how best to ensure it reflects the reality of prescribed medication and treatment. There are a range of existing legal pathways available to support people with disability who experience discrimination, including under the Equal Opportunity Act 2010 and the Fair Work Act 2009. Employers also have a positive duty to eliminate, as far as possible, discrimination in their workplaces. As we said in the government response to the inquiry into workplace drug testing in Victoria, expanding the definition of discrimination in the Equal Opportunity Act to expressly capture the use of prescribed medication or medical treatment for a disability requires further consultation and analysis and the consideration of the resourcing and economic impact of Victorians. This is certainly not a question of whether protection should exist. It's about ensuring any changes are clear, workable, and do not create unintended consequences. And I'm mindful that some industries certainly require robust alcohol and drug policies to ensure the safety of employees and the broader community. And our government is committed to ensuring that workplace drug testing treats all workers fairly, respectfully, and with dignity. Whether it's through the nation-leading wage theft laws, the introduction of industrial manslaughter laws, laws that were introduced before I entered this place, but certainly I was able to watch on from afar and show my considered support for. You see, the implementation of the vital nurse-to-patient ratios or the guarantee of free TAFE, which only passed yesterday in this chamber, this government has always placed the focus and interests of workers at the very forefront of our agenda. And this bill encompasses the broader scope of medical treatment, and it's important to reflect on Victoria's role as a pioneer in medical cannabis reform, as these progressive shifts are a landmark of Labor governments. In 2016, Victoria made history as the first Australian state or territory to legalise medicinal cannabis under prescription for therapeutic uses. This was not an overnight decision. It's a core commitment that we took to the 2014 election, and one that we've proudly delivered for the community. And it's one that I have indeed spoken about a number of times in this place. And you see, that landmark reform followed the 2015 release of a comprehensive report by the Victorian Law Reform Commission, which carefully detailed how a law could be amended to allow people in exceptional circumstances to safely access medicinal cannabis. Since then, this change has been a genuine game changer for Victorians seeking therapeutic relief. We recognise that people with a disability should not face discrimination simply because they're accessing these prescribed medications or other necessary medical treatments. And as we look to the future, we remain committed to ensuring our laws continue to evolve to reflect the lived realities of all Victorians. And in other areas, we believe in equal opportunity for Victorians with disability across the places in which they live, they work and they play. We provide for disability inclusion support in our schools, a reform delivered by this government to providing practical infrastructure support to kindergartens through the Building Blocks Inclusion Grants. We also support Victorians with disability with transport assistance through the multi-purpose taxi program. And when it comes to NDIS, our state provides a $3.2 billion contribution each year to ensure Victorians get the support they deserve. We're also taking the lead in housing, where our government is currently the largest provider of specialist disability accommodation in the entire state. And I think that was a contribution made by earlier speakers to this debate. I will also just perhaps take a moment to reflect on the disability inclusion in school settings, and it certainly is something that I was able to examine as part of the school funding inquiry, which is currently underway through the Legal and Social Issues Committee. Can I just thank Mr McCracken for his work in bringing that inquiry. He chairs it, and through that we've been able to hear from a range of witnesses, which is publicly available, but I do look forward to that report being tabled in this place rather soon. We aren't just providing beds in our state as part of that work I spoke about earlier with the specialist disability accommodation. We're also ensuring that buildings are fit for purpose through the construction of new homes. In fact, there are 27 new homes, with 19 already completed and a further 8 they're under construction. This level of commitment is what real progress looks like. It's not about building a state where disability is not a barrier to a full life, whether it is in the classroom, it's a workplace or it's in your home. I've got to say, at the midway point that we are of the current state disability plan, the vast majority of actions outlined in the plan are either completed or on track. And some of these achievements, including the appointment of the Chief Accessibility Advocate within the Department of Transport and Planning, and the endorsement of the National Principles for the Recognition of Assistant Animals. There's the Sport and Recreation Victoria's Together More Active program, investing $1.74 million to support 15 inclusion, participation or workforce development projects. There's disability liaison officers in schools, responding to 37,500 referrals from people with disability seeking support to access healthcare. And I had the good fortune, as part of the earlier testing with Metro Tunnel, in fact, to work with the disability inclusion folks to make sure that the Metro Tunnel was world class in disability inclusion, and it's certainly been something that's been strongly fed back from disability advocates since taking on the Metro Tunnel and seeing those 5 new stations. Now look, I also want to, perhaps the benefit of having the Minister for Mental Health here is also to talk about the government's funding of the Mental Health Interface program, which strengthens the interface between consumers, mental health inpatient services and the NDIS. There is also Homes Victoria, which is using best practice universal design principles in social housing. And there are 34 specialist disability practitioners that are supporting families with disability to access the NDIS and further supports. And there's something dear to my heart, is the Emergency Management Victoria's new position as a Senior Advisable for Accessible Communication role, which ensures that accessible public communications are available in our emergency preparation, response and recovery. And in fact, only yesterday was I speaking to representatives from autism organisations here in Victoria, which are presenting and meeting with members in Queen's Hall about the importance of accessible communications for people with autism in emergency settings. And so I will say that work around advocating for people with disability, it never stops. And the Victorian Disability Advocacy Program continues to fund agencies that support systemic and self-advocacy for people with disability. There's Family Safety Victoria, and their embedded universal design, disability confident and inclusive workforces into the policy and programs. And the planning for people with disability and their families, making sure that they are centred around considering the needs of victim survivors of family and sexual violence. Of course, as I mentioned earlier, the Victorian Government schools are using disability inclusion funding to recruit and train staff and purchase and upgrade resources. There's 1,240 schools that have transitioned to new funding and that model. And of course, across the entirety of the Victorian public sector, the Victorian Public Sector Commission is leading a work co-designing a neurodiverse employment toolkit to support the recruitment and include workplace adjustments for neurodivergent employees, something that has in fact come up again with some of the representatives from organisations that are here all week with the autism organisations here at the Parliament. So there are state-owned creative organisations, including the National Gallery, the State Library Victoria, Museums Victoria, the Arts Centre Melbourne, that continue to be guided by disability plans and routinely host accessibility events. These are just some of the examples of our progress that certainly this government is making towards a more inclusive and accessible state. Of course, like I've just outlined, there is work that continues, whether that's through the Legal and Social Issues Committee and our inquiry right now into school funding, or in fact just many advocacy meetings and efforts that are continuing to take place with disability organisations. And so whilst I know that this is certainly a very worthy bill, I reiterate my earlier position. Thank you.
Mr Batchelor.
To rise to speak on the Private Members Bill, the Equal Opportunity Amendment Medical Treatment Bill 2026, which seeks to amend the Equal Opportunity Act to provide for the protection of persons with disability from discrimination on the basis of using prescribed medication or receiving other medical treatment for that disability. The bill substantively seeks to insert some additional provisions in the meaning of discriminations section of the Equal Opportunity Act that effectively attempt to mirror an existing section in the Act that describes what is meant by disability. Obviously, the structure of the Act, after describing what attributes are protected by the Act, follows on in Section 7, talking about what discrimination means, and talks about direct or indirect discrimination on the basis of an attribute or a contravention of other sections. And further, that discrimination on the basis of an attribute includes discrimination on the basis of a range of other characteristics. There is an existing provision in Section 7.3 that states that for the purposes of the meaning of what discrimination is, extends the meaning of that discrimination to the presence of an assistance aid being accompanied by or in the possession of that assistance aid is taken to be a characteristic that person with the attribute generally has. And essentially using that structure, the proposals put forward in this private members bill seek to add further clarification that the use of medication, so the analogy being drawn between aids and assistance equipment to medication, being prescribed to the person by a registered health practitioner for the medical treatment of that disability, and the use of that medication is taken to be a characteristic that the person with that attribute generally has, and therefore the construction of the preceding sections of the Act would render that use of that medication properly prescribed to be one of the elements that is brought into the calculation of what is meant by discrimination against the attributes defined earlier in Section 6 of the Act. The genesis of this private members bill from our colleagues Mr Eddershank and Ms Payne comes from a range of sources. There's been a lot of advocacy here. Obviously, we considered some of these issues, and some of these issues were raised during the Legislative Council Legal and Social Issues inquiry into workplace drug testing, which I think was in 2023 or 2024, but the years and committees seem to blend into one at this point of the term. But there was some really interesting evidence given to that committee about how particularly workplace drug testing arrangements occur, and how certainly the way that many witnesses came forward to that committee and described how their experience of being at work and using prescribed medication were being impacted by actions of their employer. And certainly on the face of what this private members bill seeks to do is to ameliorate and provide action with respect to that purported discrimination for the in protection of the attribute of a person with disability using medication. Obviously, there are a range of matters that are, in terms of the operation of the Equal Opportunity Act, that apply here. There is a fundamental commitment from the government to making sure that Victorians with disability have their legal rights protected, and that the range of matters that evolve and change in the broader community with respect to the discrimination and issues that people with disability face are ever changing and do change over time. And we as a government are always cognisant of those issues and monitoring them and making sure that we strengthen those protections. The way that the government is seeking to progress these issues is not by way of a private members bill. And so, as further speakers have articulated, whilst there may be some good reasons why some of the issues that are seeking to be dealt with by this bill need to be addressed, the government is not of the view that this bill is the vehicle to address them. So what we have done has been to strengthen a range of matters with the Equal Opportunity Framework here in Victoria. It was a year ago that we made some pretty significant changes to a range of anti-vilification laws that have changed and strengthened the protections, particularly that people with disability face, and brought stronger protections in those laws, in the anti-vilification laws, to include attributes of disability into the broader protections that exist within the anti-vilification framework. So I think that's just one example, a very concrete, real and recent example, having those laws passed this Parliament a year ago this week, came into effect sometime later, but passed through here a year ago, sought to and indeed have now included have included disability as an attribute that is protected by that anti-vilification framework. I made a member statement earlier that highlighted that, of course, those laws that we passed last year that included disability as a protected attribute under the anti-vilification laws were laws that were opposed by the Liberal Party and by the National Party. And so, as I mentioned in my member statement earlier today, we still haven't been told by them why they voted against those laws last year. And earlier today I was talking about it in the context of religious and multicultural groups being the beneficiaries of the protection that that bill introduced, the Anti-Vilification and Social Cohesion Act that was put forward and passed by the Parliament last year. Earlier I was talking about the other provisions, but it's equally as relevant now to remind the Parliament that the Anti-Vilification and Social Cohesion Act that we passed last year also included the protection of disability as a protected attribute. So I think that what I'm trying to say with that, President, is that it's very clear that the government takes the protection of people with disability and strengthening the rights of people with disability very seriously. We have made substantial improvements to the protective framework that exists in a range of laws to that. The issues that are sought to be addressed by this bill through the amendments to the Equal Opportunity Act are ones which we have received considerable evidence and have received some quite heartfelt witness testimony as to what the benefits would be. It's that the government doesn't view this private member's bill as being the vehicle to achieve them.
Mr Talamas.
I move the debate on this bill be adjourned to the next day of meeting.
Questions and motion be agreed to. All those in say aye. Against no. I believe the ayes have it. We'll now move to statements on report.